Good morning, everyone. Welcome to part 2 of Sheehan Finney's 33rd Annual Employment Law and Update. My name is Kelly Trudell. I'm the Director of Business Development here at the firm, and it's my pleasure to welcome you to day 2 of our virtual seminar. On Tuesday, we had nearly 400 people, and today we are expecting close to those numbers. Before we get into the program, I'd like to share just a few brief housekeeping items with you. This session will run from 8:30 to 10:30. And we would encourage you to submit questions at the bottom of your screen using the Q&A tab. Presenters have reserved some time at the end of each session to address your questions. Please type them using this tab. Please complete the evaluation form at the very end of the program. We really use this feedback and commentary to help improve our comments, to improve our content, excuse me. Following the program, we will distribute the materials, a recording of the webinar, and all of the credit information that you will need to submit for credits. We're very pleased with the turnout and hope you are pleased as well. Right now, I'd like to welcome Jim Reedy, co-chair of the Employment Law Group, to the program. Thanks, Jim.
Good morning. Thanks, Kelly. Great to be here. As Kelly said, day 1 of the program on Tuesday was a great success, and we're really excited about today's program. But first, we have part 2 of our special guest presentation, a discussion with Governor Sununu.
So let's talk about that, the magnet of drawing folks, businesses, and people to New Hampshire. Some states are looking at vaccine passports and things of that nature, travel restrictions. Employers in New Hampshire are starting to send their employees back out again for business and beyond the borders of New Hampshire. But as you look to that, and also for people coming in, would New Hampshire ever consider, or what are your thoughts about a vaccine passport?
No, really. You get down a rabbit hole, so many problems when you start talking about vaccine passports. You're really just disseminating between the haves and the have-nots, and you're doing it on a medical basis, right? Who has a vaccine, who doesn't, why this person needs exemption, why this person doesn't. Can you imagine the burden on HR? If you have 2/3 of the staff saying, well, we're vaccinated, and 1/3 of the staff saying, well, we're not going to get vaccinated, and 5 individuals saying, well, I have this medical condition, so I can't get vaccinated. And so now you're starting to move everybody around within the office, and people losing their jobs because they couldn't get a vaccine. I mean, it would be a mess within its worth. Folks are going to choose to get the vaccine, or they're not. And folks are choosing to protect themselves, or they're not. And that's absolutely their choice, and that's fine. As long as those who want that protection have that protection and that opportunity, that's what's most important. And we've been able to provide it.
So for our HR professionals out there, and that's the audience today, Governor, a word for them about what they've been through in the last year and what they can look forward to.
Well, again, just to reiterate, a huge thank you. You guys have some of the toughest jobs for jobs, and your job is to keep everyone happy, keep it all moving forward, and let the powers that be, the CEOs and the COOs, to know what the laws are, what the regs are. And that's been a very, very tough thing over the past year to understand, as things have been pivoting moment by moment. How do we interpret this? What does it look like for our business? And so God bless everyone who's been on the front line. Still a lot of work to be sure. And there are still going to be some trying times still ahead as we transition out, but also opportunity. We're using technology, right? How are we going to use our Zoom calls and our Zoom meetings? I know a lot of folks want to come back to the workplace. I think that's phenomenal. But for those who are still struggling with that, how can we use some of these technologies that have just bloomed for us, for all of us, frankly, and that's an opportunity. So there's always a silver lining here. New Hampshire is still going to be a place for workers and businesses to come. We don't seem to have enough. Our economy is still outpacing our workers, but we are one of the fastest growing states in the Northeast. That's great. But our businesses are growing even faster. So we just have to find that pathway to keep up. Whatever you guys whatever you have been doing, just keep it up. Keep doing some really good stuff. And also we try to be very responsive and let us know how we can make things better, what might be happening. We try to get granular and as one-on-one as we can with a lot of our issues. One thing I say all the time is, if this one business has this one issue and we spend a lot of time trying to fix that one issue, chances are there were 100 other businesses with the same problem, but just didn't pick up the phone to us, right? So I try to encourage folks to spend time on those one-on-one issues, because you're not just helping one business, you're really helping the entire system.
Great. Well, thank you, Governor. Brighter days ahead.
Absolutely, thank you.
Well, if that confirmed nothing else, it is that I have a face for radio. So the first part of our program, we talked about on Tuesday, we talked about sort of the COVID-related workplace issues. And we did recent developments looking back in labor and employment law, looking back over the last year. Then we talked about managing remote workplace accommodations and data security and safety with remote workers, and also with remote workers protecting your confidential information and trade secrets. Today, we transition, as the governor's remarks, we're talking about looking forward to a post-COVID workplace. And that's the focus of today's presentations. We're going to look at first at the American Rescue Plan and guidance in that regard, followed by labor relations, the latest developments and what we could look forward to in the next couple of years, OSHA workers' comp issues in potential COVID long haul, and then finally, what might be on the horizon for purposes of workplace bills and regulations and agency activity. So as we kick off the program, please welcome my partner, Karen Whitley, to talk about the American Rescue Plan. Karen.
Good morning, everybody. So I will be talking about the American Rescue Plan Act, and this is a very comprehensive piece of legislation. I'm only really going to be talking about two of the key points that I think are affecting employers right now. And although Jim said we're looking forward, the pieces that I'm talking about really are expected to end as of September 30th of this year. So this is a pretty focused period of time that employers need to be paying attention to, but we'll be covering the COBRA and FFCRA implications of the American Rescue Plan. So the American Rescue Plan, which I will call ARPA, was enacted on March 11th of this year, and it provides a number of different benefits, obligations, and rights. Jim covered some of these in his presentation on Tuesday, so I commend those materials to you. But some of the highlights of ARPA include direct payments to low-wage workers, assistance to unemployed workers. So there have, as you all know, there has been a bump, or there was a bump of $600 per week for unemployment benefits under prior legislation in 2020. It is now $300 a week. But as Jim noted on Tuesday, and Governor Sununu mentioned, I believe on Tuesday in his excerpt there, that the state of New Hampshire is going to be one of the states that withdraws from that program in June. And so that $300 a week supplement will not be available to employees, even though it is something that is contemplated in ARPA until September. We'll spend some time talking today about the COBRA subsidy, which is available through September 30th. And then there's a number of other aspects of ARPA, including increased funding to OSHA because of the uptick in complaints to OSHA about safe workplaces and whether employers have provided sufficient protocols to keep employees safe during the pandemic. Also provides funding to unemployment insurance systems. Some $350 billion for emergency funding to state and local governments, and a whole range of other initiatives for vaccines, school assistance, tax credits, et cetera. So as I said, very comprehensive. And what I thought I would do today is talk about the aspects that I think are front of mind at this point for employers. So first go to a poll question. Number one, did your company offer COBRA to workers in 2020 due to a reduction in hours or due to layoffs and terminations? So if you could choose one of those, yes, but most of those workers are back at work and on our healthcare plan. Yes, but most of those workers declined COBRA. Yes, most of those workers are still on COBRA. No, we're too small for COBRA. And no, we maintained their health insurance because these actions were temporary. So we'll wait for Andrea behind the scenes to tabulate. And it looks like the majority of companies did maintain their health insurance. We did see that quite a bit with furloughs. And so companies were maintaining their health insurance during that period of time. But it is interesting to see that of those who were offered COBRA, many of those workers declined that. But we will talk a little bit further about what that means to offer COBRA, and if you did, and people declined it, what the impact of that is. Okay. So under ARPA, well, let's first speak sort of generally about COBRA. As you may know, COBRA is a law that's been around since 1985, and it allows continuation of group health plan coverage if employees lose their health insurance due to what's known as a qualifying event. And there are a number of them. I've listed just a few. So if an employee loses their job, that employee and their spouse and dependents could be eligible for COBRA. Divorce, losing dependent status. So again, a number of qualifying events for COBRA generally. Under ARPA, if an employee is eligible for COBRA and elects COBRA, when the employee loses their coverage for certain reasons, then the employer, in this case, I'm speaking to employers, so I just will keep the focus on what the employers have to do. Employers must pay 100% of the COBRA premiums plus an administrative fee. So it could be 102% of the COBRA premiums for the employee, spouse, dependents. And that premium subsidy, the 100% subsidy, is in effect for COBRA coverage for the period April 1st, 2021 through September 30th, 2021. But in exchange for the employer paying those premiums, the employer receives a refundable tax credit for amounts paid. So if the employer has to pay more than it would receive for a tax credit, it would get a refund. So that's the refundable tax credit piece. So let's dig a little bit more into when this would apply. So if an employee and family members who are enrolled in a healthcare plan, they may be eligible for a subsidy if they lose coverage due to the employee's voluntary or involuntary reduction in hours or involuntary termination. And I will say that that clarification that I've underlined, voluntary or involuntary reduction hours, is just something that we all became aware of within the past 10 days. And I'll get into that in a minute. So if an employee has a loss of coverage due to one of these reasons, reduction in hours or termination, involuntary termination of employment, and if the employee elects COBRA, and if the employee is still in their COBRA eligibility window, and typically that's 18 months, but that can be extended at 18 months. As you may know, under COBRA, that's the general time frame that COBRA continues, but there may be extensions of that. For example, if there's a disability that arises during the 18 months, the employee can extend COBRA coverage. So if they're still in their 18-month COBRA eligibility window, even if the employee didn't sign up for COBRA when it was first offered to them, or even if they had COBRA and they dropped it, then they would be eligible for this subsidy. And people on the extended COBRA, for example, they had 18 months of COBRA, there was a disability or some other reason that COBRA can be extended. If they're in that extended disability, that extended eligibility, COBRA eligibility period, they can still get this subsidy for any COBRA coverage during the April through September timeframe if you look back at their original reason and it is a voluntary or involuntary reduction in hours or an involuntary termination. An employee is not eligible for the subsidy if they lose coverage due to their own resignation, due to gross misconduct, or for a reason other than a voluntary, involuntary reduction in hours or involuntary termination. So there may be people who have COBRA now, but if the reason that they are on COBRA is not voluntary, involuntary, they would not be eligible for this subsidy. Also, an employee has to go ahead and elect COBRA. They are not eligible for premium assistance for the period prior to April 1st or after September 30th at this point. And they're also not eligible, and this is important, if they get this premium assistance from an employer, but they become eligible for other group health care, or if they're eligible for Medicare, then they are not eligible for this premium subsidy. And if their 18-month COBRA coverage period ends in the middle of the April to September timeframe, then this subsidy stops when their COBRA eligibility stops as well. Now, COBRA is a law that applies to employers with 20 or more employees. There are many states that have mini COBRA laws, so ensuring healthcare continuation for employees, for employers with fewer than 20 employees. And ARPA does say that the subsidy may be available for continuation coverage required under state mini COBRA laws. The New Hampshire Insurance Department has issued a guidance way back in April, so after this law was enacted, but before some of the most recent guidance that's come out. And that Insurance Department guidance does say that premium assistance may be available for New Hampshire State Continuation Program beneficiaries. That has not been updated since the most recent Department of Labor IRS guidances, so it's important to check in if you are a smaller employer. If an employer allows, under this program, an individual can switch to different coverage than what they had while they were an active employee, as long as it's not more expensive. And it's also important to recognize that many people don't take COBRA because they can get cheaper health insurance on the marketplace. And under this program, an employee who's enrolled in an individual marketplace plan can switch to COBRA to get this subsidy, but they're going to lose their tax credit under the marketplace plan. So they cannot collect both. So what are employers supposed to be doing? So the next steps for employers will be to identify who are the eligible assistance eligible workers or individuals, including going back to former employees who were offered COBRA and maybe accepted it and dropped it, never accepted it, they declined it when it was offered, but looking back to the past 18 months to see who might be an assistance eligible individual. So go back and identify those workers, and then use the model notices that the Department of Labor has issued, because anybody who is eligible for this premium subsidy needs to receive a notice telling them that they have the right to elect this coverage. So there's a notice that has been put together, and it needs to be issued to workers by May 31st, which is 60 days from when the law first became effective on April 1st. And importantly, once you give this notice, and if anybody elects this COBRA premium assistance, and they proceed along April through September, the employer has to give follow-up notice 15 to 45 days before their subsidy expires. So this is potentially a headache for employers who now have to go back and figure out who needs to get this notice and when in the 6-month period their COBRA eligibility would end, and make sure that there's a second follow-up notice telling them that their subsidy is going to end in the next 2 weeks to 6 weeks. Recently, we received further guidance from the IRS about what information the employer needs to be keeping. And one of the pieces of advice from the IRS is that employers should ask for an attestation from employees that they are remember, employees are not eligible for this subsidy if they are eligible for group health coverage somewhere else or eligible for Medicare. So the employer should be gathering information from the employee to confirm that they are not eligible for other group coverage and are eligible for this subsidy. And so the IRS has suggested the use of this attestation form, which the employer then can rely on to say, we asked our employee or former employee told us they were not eligible for any other health care, and therefore we're paying this subsidy and we're taking this credit. So the employer should have something documenting their ability to take this tax credit once they've paid the COBRA premiums. So what should employers and employees be doing? The employers should be sending the notice, giving employees another 60 days to elect this special form of COBRA subsidy, offer the COBRA coverage. The failure to do so is a failure to comply with COBRA and ERISA, which is $100 per person per day for failure to give this notice, capped at $200 per family. So if a family is eligible and the employer doesn't send these notices to the employer, the spouse, the dependents, it's capped at $200 per day per family for failure to send these notices. A big red flag for employers. Now, employees are supposed to let employers know if they become eligible for other coverage or Medicare, and therefore they're not eligible for this subsidy. The consequence to the employee could be a $250 tax penalty. But if it is found that the employee fraudulently pursued this coverage and took advantage of this coverage and got their health care paid, their premiums paid for a period of time, it can be, the penalty would be 110% of the premiums paid. So just a couple of resources. The Department of Labor put out their guidances, I think in April, but as of May 18th, the IRS gave us notice 2021-31, which contains probably about 5 single-space pages of description of what the law requires, and then 86 FAQs separated into various categories. So really helpful, word searchable to get to your particular issue. So, poll question number 2. Did your company / organization continue FFCRA, Family First Coronavirus Response Act benefits into 2021? Yes, no, or I thought it expired in December 2020. Magically. Okay. Wow. Actually, this is more than I have seen from my clients. So this is very interesting. Did your company continue the FFCRA benefits into 2021? And 59% of you say yes. And that, again, I have seen, for reasons that we'll discuss in a minute, I have seen many employers saying no. So this is heartening. And to those of you who thought that it sunsetted in 2020, we will talk about that. You are correct. The mandatory part of this did end as of December 31st, 2020, but there's a voluntary ability to carry it forward. Okay. I'll just make sure. Yep. Okay. All right. Good. So as I just said, the mandatory Families First Coronavirus Response Act benefits did expire on December 31st. But in December of 2020, Congress allowed employers to choose to extend those benefits through March 31st, meaning that if employers chose to do that, they could take a tax credit for wages that they paid for the 6 reasons that the FFCRA had been available from April 1st, 2020 through December 31st, 2020. So there was that brief extension through March 31st for the same reasons in December 2020. But then under ARPA on March 11th, 2021, Congress then extended FFCRA on a voluntary basis, a voluntary extension for employers with fewer than 500 employees could extend FFCRA paid sick, whoop, don't know what happened there, paid sick and family leave benefits, again, from April 1st through September 30th. So basically what this does, if the employer chooses to offer the FFCRA benefits, they can take the tax credit. But in addition, the ARPA legislation expands the list of permitted reasons for leave. So let's dig into that a little bit. As under the COBRA subsidy, when an employer pays for these FFCRA wages, the employer receives a refundable tax credit against the employer share of the Medicare tax. So this includes wages, but also related health plan expenses and taxes on those wages if an employer provides paid sick or family leave to employees who cannot work or telework for COVID-19 reasons. The IRS has issued tax credit guidance, but as of yesterday, the Department of Labor had not issued any follow-up guidance. Now, you may remember last year when FFCRA came into effect, it took effect on April 1st and the regulations came out the same day, and there were many updates over the course of the next few months with FAQs, which were very, very helpful to help employers weave through some of the scenarios. Unfortunately, at this point, although it was expected, we do not have guidance from the Department of Labor to help employers really figure this out. So what is available under ARPA if an employer chooses to continue FFCRA, which the majority of you have? If the employer extends paid sick leave for the period April through September, there's a new allotment of 80 hours or up to 80 hours of paid sick leave for those workers, paid at 100% of pay for the employee's own care. For the original FFCRA reasons, so I need to go I need to quarantine, I need to seek medical treatment because I have symptoms, I have to care for a child whose daycare or school is closed, etc. But there's now two more reasons. First, an employee can take paid sick leave for the time waiting, or sorry, three more reasons. Time awaiting results of the COVID test due to exposure, or because an employer requests that they get a COVID test. Time off to get a vaccine, and paid time off to recover from side effects of the vaccine. So the list of reasons has now been expanded. And in addition, we have the emergency family medical leave portion. If you recall, that was previously limited to, it was 12 weeks, but it was previously limited to the childcare reasons. So my child's school is closed or my daycare is unavailable and I need to take leave to care for my child and there's no one else available suitable to do that. And so that was the previous use of this 12 weeks of leave. However, under ARPA, if an employer extends EFML for the April through September timeframe, it is now 12 weeks in a 12-month period. Now remember, under FFCRA, it was 12 weeks, but the first 2 weeks were unpaid. Now it is all 12 weeks are paid. It's 2/3 pay up to $200 a day or $12,000 in the aggregate. And even though it was limited to childcare reasons before, now all of the permissible ARPA reasons, including recovering from effects of a vaccine, may be eligible. Employee may be eligible to take that leave. So we now have a couple of additional restrictions or clarifications. The credit is not allowed if an employer discriminates in favor of highly compensated employees, full-time employees, or employees on the basis of their length of employment. So there are some discrimination elements here. If an employer picks and chooses, they would not be able to get the tax credit. Also, the credit is not allowed if the employer received a PPP loan, which was forgiven for the same time period, but if the PPP loan is not forgiven, then the employer would be able to take this. Now, there are a number of unanswered questions, and as I mentioned, the Department of Labor, it was widely expected that they would issue some guidance here. But right now, some of the questions that we've seen is, can an employer offer paid sick leave but not EFML? And I will tell you right up front, these are questions I do not have the answers to. We have worked with clients to try to figure this out. But without Department of Labor guidance, it's a little bit risky to offer one and not the other. But some additional questions: could the employer continue to offer just reason number 5? In other words, the childcare reasons. You can take up to 12 weeks off for childcare and not the rest. But what happens if the employer didn't offer it right away because the employer was waiting for new regulations or FAQs? Can they offer it later? So for example, if this afternoon the Department of Labor comes out and answers some of these questions, will they allow employers to say, okay, well, we have now the summer and September to offer this leave? Should we go ahead and do it? Another pressing question is, what documentation can employers request? I mean, you may remember under the FFCRA that there were not many pressing questions or detailed questions that an employer could ask to verify that the leave was necessary. Employers were not allowed to ask for medical documentation of the need for leave. They were allowed to ask for the name of the doctor who was recommending a leave. Now, one thing that's changed a little bit is we have EEOC guidance that says that employers can ask now employees for proof of vaccination. So the question is whether that is something also that would be needed or recommended to ask for to take this tax credit. And my biggest question is, has a lack of information led to employers not offering this benefit? It looks, as we saw in the poll earlier, as though the majority of you have gone ahead and offered, even though you didn't have this guidance. But it is curious as to whether the 39% of you who did not offer FFCRA might have done so with a little bit more clarification. So I see I have many questions and just a couple of minutes before I pass it on to Liz. So let me see if I can. Great question. Okay, well, question number 1, does the involuntary loss of coverage have to be related to COVID? And the answer to that is no. There is the FAQs spend a good deal of time talking about what involuntary loss of coverage, involuntary termination is. And involuntary termination really is something that's initiated by the employer. However, if an employee has good reason to resign, so if the workplace is not safe due to COVID, then there could be the ability of that employee to say, my termination was involuntary. It was unsafe in that workplace. They didn't have any protocols in place. So there's a really good back and forth about what contemplates or what is involuntary termination. The very interesting piece about this is the fact that the reduction in hours can be voluntary or involuntary. So remember, there's 2 bases to get this premium, and one is a reduction of hours, which can be voluntary or involuntary. So someone could say, I need to reduce my hours due to childcare and therefore go below the employer's threshold for benefits, and they could get this premium if they voluntarily reduce their hours, and they're allowed to do that. There are a ton here, and I'll tell you what I'm going to do is respond to some of these in the chat after I pass the baton. But I will say there's a question about how are they defining gross misconduct, and that is how it is defined under COBRA. So you know, you've got to be careful about, I think, calling something gross misconduct because there's a difference between terminating for cause. And the IRS FAQs make it very clear that terminating somebody with cause still allows them to collect this this subsidy. So be aware of the difference between terminating somebody with cause and somebody with gross misconduct. And again, that's a case-by-case analysis that I think would take up a lot more time than we have today. So can you define or provide an example of voluntary reduction in hours that would lead to a qualifying event? So as I just said, if you have somebody who says, I cannot work full-time, maybe because of childcare, or maybe because my healthcare provider is saying that the stress of working in this environment is too much full-time, but I need to work part-time, so I'd like to reduce my hours. That could be a voluntary reduction in hours. If they go below the 32 or 20-hour threshold for the employer, that could be enough. One more question. 18-month look back is from 4/1/21 back. It's yes. You want to look back 18 months from whenever the person, well, right now, when you're offering it. So continually look back the 18 months. So again, a lot of these questions are pretty detailed, and I will try to answer a couple of them offline, but certainly feel free to contact us. And we can walk through, because of these very detailed regulations and FAQs that we have. So with that, I am going to pass the baton over to Liz Bailey to talk about recent labor law developments. Thank you, everybody.
Thank you, Karen. And thank you for taking on that topic. That was incredibly informative. I'm going to be talking about recent labor law developments. And my focus today is going to be on not state labor law, because many states have public sector labor law, but rather the national labor law under the National Labor Relations Act and the National Labor Relations Board. And I'm going to specifically talk about what has gone on since the start of 2021, because one thing that we'll chat about a little bit is that the NLRB in particular, in my viewpoint at least, is one federal agency that can really have a very different viewpoint and position depending on what presidential administration you have in office. So if we could go to the next slide, Andrea. So the first thing that I'm going to do is we have a poll. Do you have a union in your workplace? Yes or no? And then the second question is, if your answer is yes, do you work for a public sector or a private sector employer? So I'll let you all take a minute or two to answer those simple questions. All right, this is actually what I expected to see, that the folks that do not have a union in their workplace, by and large, are private sector employers. And you see that that's a pretty significant percentage. That information seems to me to track with what I would expect for trends, both in New Hampshire, Massachusetts, and New England and nationwide. So if we can move on to the next slide. So for many of you who've answered, you are in the private sector and you do not have a union in your workplace. But I do want to talk about all of these. I think the things we're going to talk about today are pertinent to you, even though you don't have a union right now, because it could be that you might someday, or it could be that your employees, in fact, are, one way or the other, the beneficiaries of protections under the law in terms of a right to organize or decide whether or not they want to have a union. So to talk about the basics very quickly, the National Labor Relations Board, the NLRB, administers the National Labor Relations Act, which is a federal law that's been around for a number of decades at this point. The NLRB is a federal agency. It's an independent federal agency. It safeguards employees' rights to organize and to determine whether or not to have a union as a bargaining representative. It also conducts elections. It determines unfair labor practices, as I have on the slide. And we're talking again about private sector employers and unions. So the NLRA and the NLRB do not apply to public sector employers and unions, just to bear that in mind throughout. And as I said, the NLRB and the law, they also protect people who are not in a union, but who might be thinking about a union, who might be trying to engage in concerted activity to voice opinions, voice viewpoints, fight for better wages or hours or benefits, and determine whether or not they want to have a union. Next slide, please. So what is going on at the NLRB in 2021? There have been a lot of really significant changes already. And to give you a sense of who the NLRB is, they are 5 appointees by the president. It is, you know, it varies in terms of the Republican or Democratic majority of the appointees. And they all have different terms of years. So you do have people cycling on and cycling off in each presidential administration. But the starting point of the new year in 2021 was a sudden removal of the general counsel by President Biden on January 20, 2021. And the magic of that, as you know, is that that was his inauguration day. That was met with a lot of controversy. It's still a controversial topic. And the idea was that the removal of the previous general counsel, Peter Robb, seemed a bit precipitous under the circumstances. That is still up for debate, but there has been an interim general counsel appointed. And why that is important is the general counsel under the NLRB is an important official. He or she will essentially be very much a policy-driven official and really, you know, the term has been used, the quarterback of the NLRB. So this position is far more than ministerial. It's really important, and it's an important signal as to where the NLRB may be going in the upcoming administration. So I think it's fair to say it's a signal that we're going in a bit of a different direction. President Biden has also appointed Jennifer Abruzzo to be the permanent general counsel. She has an immediate background as a union attorney for a well-known union, but she also has decades of experience at the NLRB herself. So that appointment is currently under consideration. In addition, there is a new NLRB chair. As I mentioned, there should be 5 members. Currently, there are 4 and 1 vacancy. And what had happened was a current NLRB member, Lauren McFerrin, was placed as the chair instead of John Ring, who was a Republican NLRB member. And what's happening now is that there's going to be a term expiring. So eventually the majority, which is now 3 Republicans, 1 Democrat, is likely going to switch to a Democratic majority in the NLRB. And I bring all this up not to get into politics, but rather just to point out that that is just literally the way it works out. And as a consequence, what we will see is many times you see sea changes in decisions, in outlooks, in viewpoints, in guidance, in rules that come out from one presidential administration to the next, depending on the philosophy that is in place. So if I could have the next slide, please. So what else has been going on in 2021? Well, quite a lot on the legislative front. Many of you have been following or at least have heard of the PRO Act, the Protecting the Right to Organize Act. That came out initially in 2020. And it was approved by the House of Representatives in February of 2020. President Trump had vowed that if it hit his desk, he was going to veto it, and it never came to pass that it did hit his desk because it never made it out of Senate committee. So in March of 2021, and Karen was pointing out the timing of ARPA, it was quite a busy couple of days in Washington because on March 9, 2021, our U.S. House of Representatives approved a revised version of the PRO Act. And this is, if it becomes law, this is going to be some very sweeping legislation that will really change the contours of the National Labor Relations Act. And it is sweeping in many respects. Just to go through a few of the points about the PRO Act that you will want to continue to follow. One of the things it will do as it stands now is to codify the Obama administration NLRB's joint employer doctrine. And what that means as a practical matter is it would make it easier for employers to be considered joint employers. Specifically, what it would do is it's going to, again, as it stands right now, it would take the 2015 Browning-Ferris decision, an NLRB decision, and apply it. And under that decision, indirect or reserved control by an employer could be standing alone enough to make someone a joint employer. So that's significant. The PRO Act would change the NLRB's union election rules. It would impose a new arbitration procedure on employers. And that is actually quite significant. Essentially, what would happen is if the employer and the union could not reach a collective bargaining agreement within 90 days, then what would happen is it would be subject to a tripartite arbitration. And the arbitrators would then be able to impose a collective bargaining agreement that would have a 2-year duration unless the employer or the union otherwise agreed in writing. So that is something that is a great deal different than what we would have in place right now. The PRO Act would also prohibit employers from locking out employees and from permanently replacing strikers. It would allow for intermittent strikes where employees are striking on an intermittent basis, which is generally considered to be quite disruptive and previously would have, there's authority that would not be considered protected activity. It would allow individuals to bring civil lawsuits in federal court for their own unfair labor practice claim and recover back pay, front pay, certain damages, and attorney's fees. And by certain damages, this is a bit of legalese, so I apologize, but it would be consequential damages, liquidated damages, and punitive damages. So a real array of different damages recoverable. The PRO Act would also provide for potential personal liability for NLRA violations for corporate directors and officers. So that's a matter of concern and significance. The real takeaway here is that this is something that if it does ultimately pass, and it might not pass in conventional sense, it might be that it looks right now that the Senate would not have the sufficient votes to get it by a filibuster. But it may be that the Democrats may seek to have this pass through a budget reconciliation process, some elements of the PRO Act. This could really create some sweeping changes for employers out there, including employers without unions right now. So something just to keep reviewing, keep being aware of. Next slide, please. Karen just spoke about ARPA and where ARPA comes into play in terms of some significant developments for unions is that it establishes special financial assistance for eligible troubled multi-employer pension plans. I guess if I had to do another poll, and I didn't put this in there because I was anticipating your answers about not having a unionized setting for private employers, I would probably have a follow-up question about, do you have a multi-employer pension plan? Those plans are becoming, with time, they've become increasingly rare, but they do exist for hundreds of thousands of employees with some major unions. And the ARPA Act essentially provides some very significant help for troubled multi-employer pension plans. And what do I mean by that? I mean plans that are either critical or critical and declining. And that is a status defined by law. And what ARPA would provide is it has a system in place now where troubled multi-employer pension plans can apply to the pension guarantee Benefit Corporation and seek to have special assistance. The PBGC is now essentially in rulemaking mode, but the employers will have through 2025 to apply for help. And the general perception is that although the assistance needs to be limited to benefit payments and plan expenses, there may not be a lot of strings attached to getting that assistance. Remains to be seen. But this is very good news for unions and for multi-employer pension plans who were concerned about potential failure. So great news for them, great news for those employees who are retirees or who are employees now in those pension plans. The assistance essentially will go through 30 years, so 2051. So this is a real meaningful development for those folks out there who have multi-employer pension plans. And I'm sure we will hear more about it. Next slide, please. So what else is going on? As I mentioned, the NLRB can change pretty drastically in terms of its worldview when it has a different presidential administration with a different political party. And that is agnostic as to what party may be in power. What has happened recently since President Biden came into office is that the acting general counsel has withdrawn previous general counsel memoranda that were issued in the Trump administration. And the acting general counsel has issued a memo on March 31st, 2021, that the NLRB intends to have vigorous enforcement of employees' rights under Section 7 of the NLRA. So that is something that I think it's good for employers to know and to be aware of, that this is going to be a different attitude going forward than perhaps what we've seen in the last few years. The general counsel had noted that, in his viewpoint, there needs to be vigorous enforcement about protection, about acts of employees that really has a nexus to protected political or social justice advocacy. And that, for instance, protection about if employees are going to the media and talking about living wages and better wages, or if employees are protesting workplace immigration raids, and I emphasize workplace, by the government. So there could be a level of employee activity that the NLRB would be favorably disposed of at this point under Section 7 of the Act, and just something to bear in mind. Another thing that has happened is that the acting general counsel has asked that Scabby the Rat complaints be sent back to the NLRB regional offices for dismissal. And Scabby the Rat is, some of you may know, is an inflatable rat that unions may put outside of a unionized employer when there is a union labor dispute going on, or even under a secondary situation where another employer is involved with the primary employer. So placing that sort of free speech outside of the secondary employer's place of business when there's a labor dispute with employer number one. And what the general counsel has said, acting general counsel has said, is that he did not think that the previous general counsel's viewpoint on this was something worth pursuing, and it was not a good use of resources to prosecute unions for this type of activity with secondary employers. So that's a new development where those complaints are coming back and going to be dismissed. And there's also been a withdrawal of proposed September 2019 rule, which would have excluded student workers at private universities and colleges from the NLRA. So right now that rule is being withdrawn. Next slide, please. And what else has happened? There have been a series of decisions that have occurred in the recent months that may be of interest to you. The NLRB has adopted an amended legal standard about whether tenure track faculty can unionize. That might be of interest to folks out there who are in an educational setting. And essentially the issue was that if employees are managerial, they would be exempt from the NLRA. And so this decision analyzed whether faculty operating as a body exercise control over decision-making areas and whether the subgroup of employees who was the subject of being unionized was included with the managerial faculty body. Before this, there had been a 2014 decision called Pacific Lutheran, which had a standard that made it more difficult to be considered, less difficult to be considered managerial and therefore excluded. And what the NLRB did was it deviated from that precedent, and it adopted a 2019 DC Circuit decision. So this is actually in terms of whether or not somebody is able to be unionized or not, this is a bit more favorable to employers or employees, excuse me. Next slide. Recently, the NLRB also addressed a blogging work rule and a solicitation distribution work rule and a signature block requirement. And that was in a case called David Sachs Productions, which came out in April. It had a couple of points that may be of interest. The blogging rule in place essentially had some language that prohibited employers from blogging discriminatory content or blogging things that would be defamatory or harmful to the employer's reputation. And what the NLRB decided was that, yes, the employee's activity had some maybe protected under Section 7 of the Act, but overall the employer's legitimate interest in protecting its reputation and in protecting its goodwill with third parties outweighed that interest. I don't want to overstate that, because I think that we are all very conversant right now with the idea that if we have very broad solicitation distribution rules, that could run afoul of the NLRA, and it's just good to, blogging work rules, and it's just good to know. Likewise with solicitation and distribution rules. So if you have rules about blogging, rules about social media, be looking at your policy with your labor council, with your employment council, just to make sure that it is narrowly tailored and it is stated in a way that is designed to protect your legitimate business interest. As Karen said in her remarks, we're focusing a little bit more on the employer's perspective, but it's just good to be knowing that and be thinking about that in your work rules. The solicitation distribution rule in this case prohibited solicitation or distribution involving third parties. And that was really why the NLRB, I think, found that that rule did not violate the Act. But again, please be looking, if you've got these rules in your workplace, please have them reviewed by counsel, because if you cast the net too wide, it could run afoul of the NLRA. And again, you might be thinking, gee, why does that matter to me? I don't even have a union. The point being that the NLRA is there to protect people who might want to form a union, and their ability to speak out and to act concertedly with one another. And solicitation and distribution can be part of that process. Next slide, please. So another decision that also came out in April involved the employer's ability to instruct employees to keep investigative interviews confidential. And I think we can appreciate, those of us who have been through disciplinary interviews or investigations, that it's very delicate. You want to keep the information confidential. You want to protect the rights of the people coming forward. And when you are talking to witnesses, you certainly don't want them ideally, leaving the process and going around and talking to everybody. and maybe impairing the investigation, or maybe otherwise, harming the people that came forward with a problem or a concern. You don't want the investigation to have a chilling effect. What this case did was it reinforced NLRB precedent that an investigative confidentiality rules, instructions that please keep this confidential, that are narrowly tailored and that specifically apply only for the investigation duration, are categorically lawful. So that's a mouthful, but what it means is just what it says, that if it's very narrowly tailored, if the instruction is this is for the term of the investigation, please keep this in confidence, that should be fine. The question is, would a reasonable employee understand that the confidentiality restriction was limited to the investigation? So it would be very fact specific. With all of these cases, I would say to you that if you have a situation that you think has, you think back and you want to look up that case and figure out what it says, do bear in mind that many of these decisions and this analysis is very, very fact specific. So if you have a situation that you question, please have it analyzed carefully, because it might not necessarily have the same outcome as these cases did. Next slide, please. And the last but not least, I think, the NLRB declined to amend its contract bar rule. What that means is that there is a very narrow window of time when you have an existing contract, collective bargaining agreement, where the NLRB will recognize a request to have an election. And it is a very small window of time. It's based on when the request is made in relation to when the current contract expires. And the NLRB analyzed the situation, and it didn't depart from the existing precedent. So it's important to know that this is one instance in which the current existing precedent was maintained. And next slide, please. So what is my prediction for the remainder of 2021? I think we're going to have a labor-friendly outlook at the NLRB and in Congress. I think that that's something that might be here to stay, at least until the midterm elections. And again, I think it's great for you folks out there who don't have unionized settings, just to keep aware of what's going on, keep aware of what you're hearing about legislation. I didn't touch upon right to work issues that I know can go on in various states and at the federal level as well, which are always out there. But do keep in touch about what's going on at the NLRA, because it may apply to you in your setting, even though you might not think it would. I really thank you for your time. I see that the questions are going down, and it looks to me like we still have a lot of questions for Karen. So what I will do is I will look through the questions as well, and I'm going to hand this over to my law partner, Brian Bouchard, who will be talking about OSHA and workers' comp issues with long haul COVID. Thanks, Brian.
Okay, thanks, Liz. I often say in these introductions that I'm a labor and employment attorney, but let me tell you, Liz is a labor attorney with a capital L. My name is Brian Bouchard. I'm a litigator at Sheehan Finney. I am also, we'll just say, an employment attorney here with the firm as well. I'm based in Portsmouth. We just opened our Portsmouth office a couple of months ago, back in March. So what we're going to be talking about today is OSHA, masks, a little bit of what's so-called mask discrimination, and a phenomenon called long-haul COVID, which has implications for FMLA and implications for workers' comp insurance particularly. Now, I created this presentation at the beginning of May, and I got to tell you, I have recreated this presentation almost every week since, as information has just trickled out of the administration about OSHA issues, about mask issues, and about long-haul COVID. So here's what we're going to be looking at today. And hopefully no new information will come out as I'm doing this presentation. If it does, you're on your own. Absolutely joking. We're always a phone call away. And we're expecting new guidance from the EEOC and new guidance from OSHA. So we'll be updating this presentation as that guidance comes out. So today we're going to be talking about some 2021 OSHA publications, the Protecting Workers Guidance and its effect with the General Duty Clause, emergency temporary standards, which I don't think we'll actually end up seeing, and the new reporting guidance that just came out. We're going to be talking about masks, CDC guidance, and OSHA responses. We're going to talk about vaccine discrimination, and we are also going to talk about long haul COVID, as I mentioned. So let's start back in January here. January 21, the president in his second day of office issued an executive order on protecting worker health and safety. And that executive order had a lot to it, but there was two primary themes. The first one was that it directed OSHA to issue new guidance on workplace safety in light of the pandemic. The second theme was that it instructed OSHA to consider issuing what's called emergency temporary standards, or ETSs. And the instruction was that OSHA had to do that by March 15th, 2021. Newsflash, it's May, we haven't seen those yet. We'll talk about whether we actually may see those at all. So 8 days later, after the executive order came out, OSHA, as if this had been planned, issued what's called the Protecting Workers Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. And for those of you who are in New Hampshire, Massachusetts, New England generally, the guidance wasn't all that revolutionary or novel. It included things that we've seen in our own state guidances, particularly the Governor's Universal Guidance 2.0. It had attributes like practice social distancing, identify hazards or hazardous areas in the workplace that may lead to the spread and transmissibility of COVID. Things like kitchens, elevators, restrooms, break rooms, or if you have someone who interacts regularly, with the public in a front-facing fashion, anyone working at a front desk, for instance, identify those areas and find ways to either block them off or mitigate transmissibility. Improve ventilation as you can. That can be as simple as installing filters, but it can also be more complex than that. Provide greater protection to higher risk individuals who may need to isolate in light of COVID. Also involves ADA issues. Isolate workers showing symptoms of COVID and educate workers on virus transmissibility and hygiene. There were also some, we'll call it more non-conventional guidance that came out from the Protecting Workers guidance that OSHA issued. But again, for those of us in New England, it wasn't all that novel. Things like provide face coverings to workers. You'll find that right in the Universal Guidance in New Hampshire as well. Provide a COVID vaccine at no cost. I would exercise caution here. If the employer is the one providing the vaccine, it's great to have that accessibility to employees, but the problem is that it raises a few ADA issues. The vaccine itself isn't considered a medical exam, but those questions leading up to the vaccine that someone has to answer in order to get the vaccine, that would be considered a medical inquiry. It's being asked by the employer in the context of the employment environment. So when it's in that context, the employer basically has to demonstrate specific reasons for why those questions are being asked, because those questions are likely to elicit information about employees' disability. For that part of the guidance, I would actually recommend that employers send their employees out to a doctor if the doctor has the vaccine, pharmacies if the pharmacy has the vaccine, or any state vaccination center. Also included in the guidance, I guess the more considered unconventional parts of the OSHA guidance here were to avoid distinguishing between those who are vaccinated and those who are unvaccinated in terms of safety measures. We're going to talk about that at length, which is why there's the 2 asterisks there. And to minimize the effect of quarantine and isolations by implementing non-punitive policies and maybe even providing paid sick leave. Again, a playbook right out of the New Hampshire guidance. We've seen it before. Provide guidance on screening and testing, and to designate a workplace coordinator to answer questions and to be reviewing OSHA policies as they come out. Now, here's the moment that I think you're all waiting for. If anyone is sort of multitasking right now, I get it, but I can imagine this sort of hush just fell over everyone as you're waiting for this pronouncement. Is the guidance mandatory? The answer is no. It is only guidance. That said, when you read the guidance, OSHA really hams up the general duties clause. And the general duties clause is something in the initial or the original OSHA Act. And it says that each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees. So employers are sort of in this limbo, right? Doing absolutely nothing and completely ignoring the guidance is likely going to put you afoul of the general duties clause. That said, the guidance isn't mandatory. It is guidance. And so there is no expectation that an employer would have to do everything. What I would recommend employers do is take a look at the guidance. It's actually not that long at all. See what you've done, see what you can reasonably do, and then implement a plan going forward. I would also check OSHA's specific industry guidance, which is in the link below. OSHA promulgated regulations for pretty much every type of industry you can imagine: restaurants, healthcare, manufacturing. Take a look at that guidance and see where your practice or where your company falls within. So we are going to move on to my first hypothetical. I have two hypotheticals today. For those of you who have been to my presentations before, you know that I like to include a little hypothetical to drive a point home. Sometimes it's one we covered, sometimes it's a way to introduce a new point. So I'm going to read the question and then Andrea will put up the poll and you all can answer and we'll talk about it. So here's the question. Mark works for Painter's Paradise Warehouse and is concerned about contracting COVID-19. His cube mate, Smith, arrives one day without a mask, coughs a few times. Mark asks management to send Smith home and to sanitize the cubicle before he returns to work. Painter's Paradise refuses. Both Mark and Smith are fully vaccinated. Mark, in turn, refuses to work and is terminated. Is the termination in that context permissible or impermissible? What do you think? And I'll just give it a few minutes here. There we go. All right, looks like we are tied pretty much right down the line. 49% of you say it's permissible, 51% of you say it's impermissible. That's sort of what I designed these questions to do because it just creates good fodder for conversation. So let's go look at the next slide. All right, this is likely impermissible, though I can see both arguments. So don't forget that OSHA has what's called the 11C clause, which prohibits discrimination or retaliation against an employee who files a complaint related to the act or who asks for a certain type of safety accommodation, basically. And the protecting workers guidance that excuse me, OSHA just issued actually has a proviso in it that says employers may not discriminate against employees for raising a reasonable concern about infection control related to COVID-19, which is what this question gets at. I think some may get sort of distracted by the red herring that this individual is refusing to work. And I totally understand that. But remember, if there is a legitimate hazard that exists, the employee isn't required to go work in that legitimate hazard in order to receive protection under OSHA. So terminating an employee in that context would likely trigger an 11C violation. Now, of course, what the employer needs to consider here is what Mark is asking for, is there a reasonable concern? His cube mate didn't have a mask on, but depending on what the employer's guidance says, he might not have to have a mask. He coughs a few times. Is that indicative of COVID? Yes, but does it mean he has COVID? Maybe not. Some more investigation is certainly needed. What really, brings it home for me though is, was there some type of reasonable concern? And really, what can the employer do here? Not that OSHA really imposes, a duty to accommodate, provision, in the sense that the ADA does. But in this context, if the employee is only asking for, maybe Smith to be moved to a different area or Smith to be sent home and that the cubicle just be sanitized, that's probably worth the effort of just doing that and avoiding any type of, OSHA 11C response and potential lawsuit. So let's move on to the expected emergency temporary standards. Maybe. Until the CDC mask guidance came out, the emergency temporary standards reportedly were going to include a mask mandate for all employees, regardless of industry and regardless of really the state. So it'd be a national mask mandate in the workforce for companies. Workforce training on things like hygiene and things like virus transmissibility, social distancing, and a written COVID-19 response plan. Every company would have had to create a written response plan. Like I said before, it would be a national program. OSHA actually submitted draft ETSs, according to a few sources at the Washington Post and New York Times, to the White House on April 26, 2021. Importantly, OSHA hasn't issued an emergency temporary standard since 1983. It's the only time it's ever done it before, and that was related to asbestos, and it got turned down in federal court. So this would be pretty novel and revolutionary territory if, emergency temporary standards were actually going to come into effect. If they were to come into effect, they would be binding temporary rules that do not require your typical rulemakings, other agencies, at least initially. There'd be no notice and comment periods, no public hearings, nothing like that. They would get published, they'd be immediately enforceable, and they'd be immediately enforceable or until withdrawn or until a 6-month period. At the 6-month period, then OSHA would have to go through the typical notice and comment period to make them actual permanent rules of the organization or of the agency. I don't think we're actually going to see ETSs, particularly in light of the CDC vaccine requirement, not vaccine requirements, mask updates that just came out, but it's possible that we still might. If we do, just know that these things are immediately enforceable until a federal judge says that they may not be, or until OSHA withdraws them. So we're going to talk about OSHA reporting in light of COVID-19. This is new guidance that came into effect on May 26, 2021, so yesterday. And it was published on May 19th. So this guidance recognizes that COVID-19 is a recordable illness in terms of OSHA reporting. And it is if these 3 factors are met. One, the case of COVID-19 is a confirmed case, there's a confirmed test, okay? The case is work-related, and the case involves 1 or more general recording criteria. What that means is the event or the injury results in somebody's death, someone missing work for an extended period of time, having to have an employee's job restructured because of the illness or because of the work injury, or medical care that goes beyond typical first aid care. Keep in mind that OSHA is ramping up recording enforcement to contain workplace transmissibility. So be sure that if you have a COVID event, that you do record it. Just note though that just recording a COVID illness, OSHA has made clear here that that itself is not a violation of an OSHA standard. Not recording it is, but just because you have to record one, it doesn't mean that you've done anything wrong as an employer. So let's talk about this just a little bit. I think some of you are probably wondering, well, okay, this is a virus that quite literally spreads through the air. How the heck do I know if it's a work-related event? And that's a really fair question. OSHA's done an okay job of trying to provide some guidance here. I think the guidance could be a little clearer, but it's doing what it can in the middle of a pandemic. So here's what we need to talk about. We need to talk about 3 factors that an employer would have to go through, or 3 steps an employer would have to take if there is a confirmed OSHA, a confirmed COVID diagnosis. 1 is that the employer has to make a reasonable investigation into whether the COVID diagnosis is actually work-related. Okay, you don't have to undertake an extensive medical inquiry, in part because there's privacy concerns, there's ADA concerns, there may even be HIPAA concerns. But you have to ask the employee how they believe they contracted the virus. And while still protecting privacy, discuss what the employee was doing at work and maybe discuss what the employee was doing outside of work. Did they go to a concert? Did they go to Fenway? Were they at a graduation sitting with 3,000 people in bleachers? That type of thing that may provide some information as to whether the confirmed case of COVID would likely have been contracted outside of the workplace. And then review the employee's work environment for COVID exposure. Are they someone that delivers merchandise to restaurants and interacts with the public, on a fair basis? Are they a community ambassador? Are they, going to nursing homes regularly or hospitals regularly? Are they really a customer-facing role? That type of environment may make it more likely for an employee to contract COVID in the workplace. The other thing that an employer has to look at is timing, okay? OSHA is just asking, as part of the investigation, that an employer look at the time, reasonably available at the time it learns of the diagnosis, okay? You don't have to do a month look back. You don't have to do a 2-month look back and look at other types of evidence. It's just what's available to you at the time you learn of the diagnosis. That is the parameters of your investigation, sort of the universal, not the universal, but the universe of evidence that you're going to be looking at. And finally, OSHA has provided some guidance as to what type of evidence you're going to be looking at. I'm not going to be going through all of these. I'm just providing it as a resource for you so you can look at it later. But, an employer is going to be looking at things like, is the illness is work-related if the employee's job includes having frequent exposure to the general public, things that we just talked about, like someone who's a community ambassador. At the same time, the illness contraction may not be work-related if that employee was the only person to have contracted COVID, okay? So take a look at these when you're doing your investigation. They'll help you as the company to determine whether or not the person who contracted COVID-19, whether that was work-related or not work-related. So what you're looking for here is to make a determination as to basically, is it more likely than not that the employee contracted COVID-19 in the workplace? If it's more likely than not, then you have to record it. If you can't get to that 51% standard, then you don't have to record it. Keep in mind though, that if you do have to record a COVID-19 incident, okay, this is going to be considered a respiratory illness and it's going to be recorded on your Form 300 log, consistent with the recording policies and procedures manual. Now, let's go on to everyone's favorite topic, which is masks. March 13th, 2021, so-called Mask Liberation Day. As probably everybody knows now, the CDC issued updated guidance affecting mask and social distancing practices. If you're fully vaccinated, you can resume pre-pandemic activities. You don't have to have a mask indoors or outdoors. And you don't have to socially distance. And you don't need to quarantine after traveling either. There are still some circumstances where someone should wear a mask. If you're traveling on airplanes or other public transportation. You're visiting a correctional facility, you're in a homeless shelter, or you're in a hospital or a nursing home, for instance. Those types of situations where you're dealing with a potentially vulnerable population still should have a mask. Now, New Hampshire, for its part, the state epidemiologist has said that public health continues to recommend in New Hampshire that everybody, including fully vaccinated people, continue to wear face masks. The concern here is that by alleviating the face mask recommendation, that it's putting a big burden on employers and businesses to determine who is vaccinated and who is not vaccinated. At the same time, New Hampshire lifted its mask mandate on April 16th, 2021. So, while this is a recommendation from the epidemiologist, employers are free to have a mask-free environment in their workplace. Massachusetts is going to align itself with CDC guidance. Masks will still be required for public and private transportation, buses, ride shares, and in facilities where there's a vulnerable population. Boston, same thing, it's going to align itself with the Commonwealth and the CDC. And in an example of an agency completely caught off guard, OSHA announced that employers should follow CDC guidance and that masks for fully vaccinated individuals will not be required in the workplace, except for the activities that we've talked about before, where someone is traveling on a public charter or someone is visiting a facility with vulnerable populations. OSHA is expected to issue new guidance on masks, and I'd expect that to come out in the next couple weeks here. So that brings us to our second poll question. Like before, I'll read it and then Andrea will put up a poll for everyone to answer. So Tricia works for ABC Corp. For personal reasons, she does not want to receive a COVID vaccine at this time. ABC management informs Tricia that she must continue to wear a mask in the workplace so that everyone knows who has been vaccinated and who has not been vaccinated as part of a general safety protocol for COVID. Is this permissible or impermissible? All right, so 27% of you say permissible and 73% of you say impermissible. And let's go and look at the next slide. Yeah, this is likely impermissible. So requiring unvaccinated employees to continue to wear masks aligns with CDC guidance. Remember that the CDC has said that you don't want to discriminate between safety measures between vaccinated individuals and non-vaccinated individuals, but again, that's just guidance. The issue that I have here is that ABC Corp appears to be tagging Tricia for her vaccination status, which could be for a reason related to her disability, to a disability if she has one. We don't know from the fact pattern, just as personal reasons, but it could also be related to a religious objection to receiving a vaccine. And it sort of sounds like here that the employer is trying to retaliate, maybe even discriminate against her for not wanting to receive a vaccine. And if it is for a protected reason, that could be complicated. But just remember that unless the question is job related or consistent with business necessity, employers must refrain from asking an employee why he or she has not received a vaccine. You can ask if someone has received a vaccine. That is absolutely permissible under the ADA. But asking the follow-up question of why may put you into waters you don't want to be in if it isn't job related and consistent with business necessity. Vaccination status is not a protected trait at the same time, unless someone is refusing a vaccine because of sincerely held religious belief or because of a disability. There is a March 2012 EEOC informal letter concerning infection control practices that's actually helpful here. And what it says is that while an employer covered by Title VII may impose masking practices or may not impose, masking practices for discriminatory and retaliatory reasons, it may do so for legitimate non-discriminatory and non-retaliatory reasons. So if you are going to differentiate in the workplace between having people wear masks and not wear masks, you shouldn't do it for a reason like we saw in the example, so everyone knows who's vaccinated or not vaccinated. That should not be the reason, but rather it should be in line with what CDC guidance says. And it should be just, hey, if you want to wear a mask, you can wear a mask. If you're unvaccinated, you have to wear a mask. But just be careful about tagging employees through any type of mask mandate or trying to identify, that's the person with a disability, that's the person with a religious accommodation. It's probably okay right now, and the fact that we're still in a pandemic and having this differentiation between masks and unmasked is going to be, I think it's going to be common for a little bit, but at some point, we may hit herd immunity here, and this question is going to become a little more complicated. But regardless, as a company, you want to have legitimate business reasons and safety reasons for continuing to have some employees follow a mask or social distancing practice. That is going to be critical. Keep an eye on House Bill 2020 in New Hampshire. It's colloquially called the Medical Freedom Bill. It effectively says that employers may only mandate medical treatment or immunization as a condition of employment when a direct threat exists. So you can't require an employee to become vaccinated, for instance. It also says that an employee cannot be discriminated against for refusing to seek medical treatment. It hasn't passed the House yet. I don't think it's passed the Senate yet. I think it's still in committee, but keep an eye on it. It would essentially provide some type of protected status to individuals who don't want to receive a vaccine for whatever reason. All right, so we're going to wrap up here with a brief conversation on long haul COVID. This is a phenomenon that occurs when someone contracts COVID-19. They basically recover, or it appears that they have recovered, but they still have manifestations and symptoms of COVID-19 long after they have recovered and long after they receive negative COVID test. So they might have fatigue, brain fog, difficulty sleeping, loss of taste or smell that endures for months, months after they contracted COVID-19, and they would test negative for COVID-19 continually, but they would still have these lingering effects. So it's been estimated that 35 to 50% of people with mild acute COVID have had persistent long-term effects for 2 to 4 months. And those effects can be severe. 9% have described their symptoms as severe. And this creates some complications for returning to work, for intermittent FMLA leave, but mostly for workers' compensation. The problem with workers' compensation is, if you have somebody who contracts COVID, appears to recover, but then has these lingering effects that may put them out of work, how do you deal with that? Well, there's a number of issues that come up. One of them is the timing of reporting. Many carriers request that reporting of a workplace injury occur relatively contemporaneously with the injury. But if someone contracts COVID-19, they may be asymptomatic, they're out of work for a day, or out for the weekend, they're fine. But then they have these long haul events that continue after. Is it possible to report those events months later after they initially contracted the virus, or after the workplace injury occurred? There's also issues with a layered cause. Long haul COVID may be caused by the virus itself and not necessarily a workplace event, which would be what is needed to trigger some type of workers' compensation coverage and protection. And the other issue is, how do you even quantify the loss here? If it is possible to trace long haul COVID back to a workplace event, well, how do we compensate somebody for the loss of taste or the loss of smell for a period of time? Essentially, what this comes down to is employers and workers' compensation carriers really open the floodgates to a host of workers' compensation problems if they just accept COVID claims as being generally going to be covered by workers' compensation, or they just accept COVID claims as, yeah, that's something that's related to a workplace event. Companies need to be very careful in what they categorize as a workplace event or not a workplace event with respect to COVID, because there can be these issues that endure for a significant amount of time. And, besides the issues with maybe a loss of taste and smell, can have serious repercussions on the individual and that individual's ability to work. So, don't just accept a claim because you think that, okay, it's COVID-19, the person might be out for, 5 to 14 days. Really do the investigation to see whether the person who has contracted COVID-19, whether that was actually caused by some exposure in the workplace. So that brings us to the end. I'm a little bit over on time, or actually I think I'm right on time. So I'll jump into the Q&A and I will see if I can answer your questions where I can. And otherwise, I will turn you over to Mr. Reedy to wrap up for the day. Thank you, everyone, for listening.
Thanks, Brian. Great job. I think that last point is pretty interesting. I think we could be seeing a battle between health insurance carriers and workers' comp carriers as to who's going to handle long haul COVID issues. And I think that's going to be something we're going to see down the road. So Brian says it's a wrap up, and it truly is a wrap up. We started the program on Tuesday talking about a look back in 2020 and the beginning of 2021 at everything from Supreme Court decisions to developments with agencies, federal and state agencies, and of course, what's going on in the legislature. But most importantly, looking at the COVID-related developments. Megan talked about remote work, and of course, the challenges going forward is having employees return from remote work. And she talked about everything from the reasonable accommodation to simply the preference. And a lot of issues are going to arise with that. There was an article came out recently that said that 1/3 of American workers who've been working remotely, if they're required to return to work, will seek employment elsewhere. So in fact, the reference was to a tsunami of job change coming. And that certainly presents its own challenges. And then JP and Michael talked about data security and protecting your confidential information when you've got employees working remotely. And that will always be going forward sort of the new normal. We had a certain percentage of employees working remotely before, and those issues were in place, but they're certainly going to be even more important as a larger percentage of our population works remotely. I thought the presentations this morning were terrific, as expected. A lot of issues to consider with regard to COBRA. There's no question about that, and the FFCRA as that continues on for the rest of this year. But some interesting twists and turns, and Karen did an exceptional job in that regard. Liz has established herself truly, as Brian said, as one of the leading labor lawyers in this state, in addition to being an employment lawyer. And I think the issue there is that it's not only for union workplaces, but also for non-union workplaces, the issues that she's raising with the change in the National Labor Relations Board, and also perhaps some developments here in the state. And of course, Brian talking about things that you don't really think about all that much, which is OSHA, the OSHA 300 log, but also an OSHA investigation. And we saw in this last year with COVID, a number of our clients had OSHA investigations. In fact, the local office of the Department of Labor says their phone is ringing off the hook, not on the wage and hour side of the house, but on the OSHA side of the house for purposes of doing investigations. And they did, as Brian said, follow CDC guidance. Until recently, they sort of were surprised by the CDC guidance with regard to masks. So, and certainly more to come in that regard. So then as we look to sort of wrapping up the program, we're going to take a look forward. What's on the horizon? Both pending workplace bills in Washington and in Concord, and also some regulations and agency activity. Just advance here. No question, 2020 is behind us, and already positive developments, whether what the governor was mentioning, and certainly what all of our presenters have mentioned, and also what you've seen in your workplaces. We've seen, thankfully, the waning of the virus, although it is still here. And as we've said before, COVID is not going to come to a hard stop. It's going to be with us for a period of time, and hopefully we won't see a resurgence with the variants, but we're seeing an opening, and that's a good thing. But now we're looking to that post-COVID era. And there was no shortage in 2020 of state laws, regulations, and federal guidance with regard to COVID. And as the virus evolved, so did the FAQs and the guidance. We saw the changes from the state, as Brian said, and also from federal authorities. I think what was particularly helpful were the guidance from the Department of Labor and EEOC over the last year with regard to COVID-related inquiries and safe workplaces and so on, and the FFCRA certainly, because you think about the FFCRA, and I think Karen mentioned that, that was legislation that was adopted in 1 week. And so there were a lot of questions, as there was with the CARES Act, and also with other things that have happened throughout the course of the year. So again, thankfully that's in the rearview mirror in large part. So Karen mentioned one of the first things we talk about is looking forward, is the immediate with the American Rescue Plan, and Karen covered that. And I think her particular focus was on FFCRA and COBRA. Lots of questions in that regard, and I've already seen that Karen's answered a lot of those. So thank you for submitting your questions. So let's take a look at what's happening in Washington right now. In the last session, we talked about things that stalled in Washington and stalled in Concord because of one partisan divide, but also because of the singular focus or near singular focus on dealing with the pandemic. So HR 7 is still, that's a perennial favorite. That's the Paycheck Fairness Act. Largely that deals with eliminating gender inequality in pay and related matters, and boosting the Equal Pay Act, the Federal Equal Pay Act, and its remedies. The FMLA Modernization Act, and so the Paycheck Fairness Act is there. You could very well see that pass the House and the Senate, given the Democratic majorities, because it had stalled for years under the last administration, but we'll see. It is a priority of this administration dealing with pay equity, and we'll see that with the EEOC as well. FMLA Modernization Act, it's not quite what you think. Now, part of the bill is talking about reducing from 50 employees to 25 employees for employers to be covered by the FMLA, but that's not the main focus. The main focus is basically to broaden the scope of FMLA leave, and that would include attending school events for parents of children, also of grandparents, school events and activities, similar to, and I think Karen talked about this before, the Small Necessities Act in Massachusetts. The Workforce Mobility Act, that's an interesting one because that is a federal attempt to outlaw or significantly restrict non-compete covenants, restrictive covenants that would keep someone from working for a competitor for a period of time. Typically, you see that on a state level, and this would be a federal bill. For purposes of banking on whether or not that passes, I think that's highly unlikely, but we are seeing a lot of activity. You saw the changes, pretty significant changes in recent years in Massachusetts. There's a bill in New Hampshire as well to continue to narrow the focus of and the effectiveness of these restrictive and post-employment restrictions, restrictive covenants. Liz talked about the PRO Act and whether or not that is likely to pass in Congress, but a lot of hidden elements to the PRO Act that are, as she said, are worth paying attention to. And the Employment Insurance Technology Modernization Act, a mouthful for sure. But for those that, of course, dealt with the CARES Act in the last year and more recently the American Rescue Plan, you know that the federal government has boosted unemployment benefits and provided additional monies on top of what you might receive, an employee may receive in the state. What we also saw in the last year was pretty significant on a national level and on a local level, unemployment fraud. And I was a victim, along with a lot of other people that we know and a lot of our clients, employees, where my wife called me at work one day and she said, I know you've been working pretty hard, but shouldn't you have talked to me about this? There was an unemployment claim that was arrived in our home, and it had my full name, my home address, the last four of my social, and the name of the law firm. And there are many ways in which this happens out there, but a lot of employers had to deal with fraud. Well, this statute is getting at improving the technology on a national level and also providing money to the states to limit the amount of fraud out there and also to help expedite the payment of unemployment benefits. The Workforce Data Act is pretty interesting. It's a study done by the, believe it or not, the National Academy of Science, and it was entered into by a contract with the U.S. Department of Labor for suggestions on how workplaces could automate and improve efficiency. And that study is underway right now. You would have thought the American Academy of Sciences was almost exclusively focused on COVID and COVID-related issues, but this is an interesting project from the Department of Labor. The American Apprenticeship Act are grants to states to improve their apprenticeship programs, and it's also direct assistance to some employers to establish apprenticeship programs. The Protecting Older Workers Against Discrimination Act. This has been kicking around in Congress for a couple of years, and it's in response to a case of a few years ago, the FPL Gross case that went to the Supreme Court that basically said under the federal age discrimination statute that the burden or the standard for succeeding on or prevailing on one of these claims was, or is rather, that age had to be the factor, but for age is effectively the standard, meaning that you had to prove that age was the reason why you weren't hired, you were fired, you were demoted, you were passed over, and so on. It's not just one reason, it had to be the reason. Now, this in part, this bill would basically go back to the standard that was existed before that, which was it is a factor and doesn't have to be the motivating factor, but certainly an important factor in the employer's decision. That actually stands a chance of passing in this Congress, and the president has indicated that he would sign that into law. So that is one worth checking, because if you look at the statistics in recent years, age discrimination claims, even though we have an aging population, are still sort of hovering around the 5th most common claim. So not a leading claim, but that could change if the standard changes. And the FLSA Modernization Act principally was to increase the federal minimum wage, although we know through executive order, the president had a change in the minimum wage for federal contractors. So let's go to the agencies and what's happening. The Department of Labor is looking at updating their independent contractor status, going back to the economic realities test. Actually goes back to the Bush administration. Some basically were saying it goes back to the Obama administration. Actually goes back to the Bush administration for purposes of what the standard is. And the standard is meant to be a relatively tough one for purposes of, we see that in the state, but we also see that on the federal level, to show basically a presumption that someone is an employee unless you can rebut that presumption by satisfying the test that, part of an independently established trade or profession, free from direction and control of the employer, and so on and so on. Under the Trump administration, that was the standard had basically the needle had moved towards more and more people being able to show that they were independent contractors. The needle sliding back to where it was before. Liz mentioned change to the joint employment standard at the National Labor Relations Board. Similarly, there was a decision from the Southern District of New York. I think as many as 8 states had challenged the Trump administration rule on joint employment, basically making it more difficult to show that 2 entities acting in concert could be deemed to be liable as the employer. That rule was vacated after this decision by the court in the Southern District of New York, and the Department of Labor has not yet issued a new standard in that regard, but they are in the process of doing that. Probably again going back to the pre-Trump era. And the Department of Labor has talked about a return to pre-litigation liquidated damages. What does that mean? If you have a U.S. Department of Labor wage and hour audit, principally, and they look at civil penalties for certain wage and hour violations, they can double those in liquidated damages if they find that the employer was either negligent or a bad actor with regard to failure to pay wages or not complying with federal wage laws. That had gone away during the Trump administration, and but it appears to coming back. That could be a fulcrum for purposes of the Department of Labor getting the employer, one, to make changes in the workplace, but also to settle up cases rather than going before the solicitor. Brian talked about the OSHA investigations and 11C. 11C perhaps being the, among all the other important things that he mentioned, 11C retaliation. Be very, very careful, as Brian said, because it doesn't have to be an actual safety violation if the employee raises a concern about a workplace hazard or his or her safety in the workplace. Even if it's not well-founded, you may have this 11C violation, and that is a particularly potent one. Just like in the area of workplace discrimination, retaliation can perhaps even be more potent than the actual underlying discrimination. And the inspections, as I mentioned, we're seeing more and more of those, and they'll likely continue for a period of time. EEOC really did a nice job in the last year in its guidance with regard to the vaccine and the increase that an employer could make, and especially with regard to, can you ask an employee if he or she is vaccinated? Can you ask for proof? And basically the answer is yes. However, you have to be careful in that regard, is not to take that inquiry and go further and get into areas that are not job related, or you're dealing with hidden disability or medical issues that you didn't necessarily need to know about. EEOC is talking about reviving the EEO2 payroll collection data. Again, remember they got it was 2017, 2018 data that they collected, and they're actually studying that now. They hope by the end of 2021 to have reviewed that data, and there's a very strong possibility coming from EEOC in a recent discussion with their office that they will reinstitute the EEOC data collection in either the fall of this year or next year. EEOC every 5 years does a strategic plan, and they've just finished the last of the 5-year plan, and they're just implementing a new one. It's consistent with, even though the EEOC is an independent commission, it is consistent in many ways with this administration's priorities, and that is looking at pay equity issues, looking at LGBTQ issues in the workplace, and following on the Bostock decision from the Supreme Court with regard to protection of sexual orientation, transgender rights, gender identity, and so on. And those are some of the discrimination claims that we may be looking at going forward, in addition to the usual suspects of sex harassment, disability discrimination, and so on. Liz mentioned the NLRB and what they're doing going forward. Very interesting. And again, it's not just that you're a union workforce, you could be a non-union workforce, and you could still run afoul of the National Labor Relations Act. IRS, I knew enough about tax law to pass the bar exam years ago, and so therefore I defer these questions to our tax partner, Peter Beach. But you'll see that there certainly will be additional guidance coming out on taxability of dependent care assistance, and certainly more coming out on the PPP program in concert with the Small Business Administration. There's no question you're going to see a sea change with regard to the USCIS. We've already seen that in many regards, from the Trump era to the current administration and the Biden administration. You're going to see, and I think a lot of employers will welcome the change with regard to H-1B and H-2B because we've already reached the caps in this fiscal year. But you'll see, hopefully, and we're talking about skilled workers and also seasonal workers, more assistance for employers. You know, again, going as high as an unemployment rate of nationally of almost 20%, locally as high as 16 to 17%. Now, nationally, unemployment rates are hovering around 3.5 to 4.5%, depending upon industries. Again, 4% being full employment. In New Hampshire, we're 2.3% unemployment. So there is certainly a need for skilled workers coming in from outside the country, and certainly for seasonal workers, agriculture and hospitality, and so on. So I think you'll see more of a change and more processing of those visas, and that will be welcome for employers. Brian talked about these new guidance. I think the thing to mention in this regard is CDC has invested $2 billion to track the variants of COVID and to hopefully stay ahead of or keep up with how the virus has mutated and so on, to avoid a situation where we're rolling back, as we've done a couple of times in the last year. Travel restrictions, I think that the problem is, as a lot of employers are starting to allow their employees to travel again for business purposes, the state-by-state guidelines that vary, and how that could affect their travel. So a lot of folks that are attending today have multi-state workplaces, and so that is certainly one of the many reasons why you want to check to see what the applicable laws are in the state. And as the governor mentioned, no vaccine passport in New Hampshire yet. However, as I think Brian mentioned, airlines are looking at that along with mask issues, but certain states have also at least entertained the idea of a vaccine passport going forward. So what does this mean? Means certainly stay informed. Guidance continues to evolve just like the virus did, and I think the important point, as you folks all know, is that federal and state authorities do not always act in a coordinated or consistent fashion. So certainly more to come in that regard. Let's take a quick poll here. And Andrea, if you could cue that up. So Washington poll question. What new law or regulation during the last year has been the most challenging for your organization? The FFCRA, CARES Act, the American Rescue Plan Act, or the CDC and OSHA guidance? And again, I always want to be a game show host. Survey says, wow, there you go, Brian. CDC guidance and OSHA guidance, almost on par with the FFCRA, and which, as Karen said, has a tail now going through the end of 2021. CARES Act was a bit schizophrenic, as we all know. On the one hand, with the PPP, it was to restore employees to the payroll. But on the other hand, it augmented unemployment benefits in a significant way, and it created, in some regards, a challenge for employers getting employees back to work. And the American Rescue Plan, I would simply say it needs to settle in more. I think the biggest surprise there for a lot of employers was, as Karen pointed out, the issues associated with COBRA and some of the twists and turns in that regard. I was amazed at the number of employers that didn't know about the COBRA premium subsidy. And but you're certainly aware of it now, and that's going to be in place until the end of September. All right. So closer to home, let's take a look at a few bills that are pending in New Hampshire. As we saw with the election last year, that there are majorities now in Congress, in Democratic majorities in the House and in the Senate. And that means that certainly there's going to be a change in priorities and a change in sort of how things make their way through the legislative body in Congress and to the president's desk. What we also saw in that election was a change in the majority in New Hampshire from a Democratic majority in the House and the Senate to a Republican majority in the House and Senate, along with a Republican governor. So there could be a shift in priority as that as well. That being said, there is still a Democratic minority in the state, and there's a Republican minority in the federal government. So you'll see a mix of bills, and we're seeing that certainly here in New Hampshire, mix of bills and priorities. So one is the COVID-19 business liability protection bill that the governor has really been pushing, which is providing liability limits for employers who've been following the state guidelines and instituted safety policies and procedures, both under federal and state, principally under state, and done a good job trying to keep their employees safe, as to whether or not they could be sued for negligence. Now, remember, there was an earlier Attorney General opinion in New Hampshire, where the Attorney General said that because of the causation issues and the uncertainty of causation, that largely workers' comp would not be covering COVID-related claims that are claimed to have arisen out of the workplace. There are 17 states, maybe as many as 19 states now, that have actually amended their workers' comp statute. So COVID could be related as a workplace injury. This bill is looking to, and it's an homage to the business industry, business associations rather, to provide some additional protection for the employers. Paid sick leave, mandatory paid sick leave, that's dead on arrival in this legislature. It's deemed inexpedient to legislate, but that one is kicked around in a couple of different sessions here because of a sense that not all employers have sick leave. It was a particularly acute during COVID, and the governor had recommended that employers be flexible with regard to granting sick leave and so on. I'm surprised that it was deemed inexpedient to legislate. I thought it would have more legs in this legislature, but that's just the way things go. Increase to the minimum wage was retained in committee. And that has been around for the last couple of years as well. But retaining wage and time records electronically, that has actually made its way through. And that's a welcome relief. It's long overdue that employers should be able to keep their time records electronically. It's just catching up with modern technology. A few others that Liz had mentioned, one is right to work. That did pass the Senate. It's before the House, and there'll be a vote in June. Right to work is you cannot require employers to, you cannot require applicants rather, and employees to join a union as a condition of employment and other related things. There is no right to work state in New England. We would be the only state in New England with right to work. Down south, there are several states that have right to work. And there's been a lot of back and forth in that. I think it's going to be tough to pass the House. It barely passed the Senate, but we'll see. Legalization of marijuana is back on the docket as well. And Brian mentioned House Bill 2020, and that is freedom from immunization. And you cannot mandate any immunization unless the employer represents a direct threat. There are a few other elements to that bill as well. That, as Brian said, that is in the House. It's actually in the House Labor Committee. Payment for unused PTO, that's been kicking around for a couple of years. That actually has got a possibility of passing, requiring employers, because employers right now, it's only if it's a policy or practice or both that you're required to pay it in New Hampshire. But that is a possibility that could pass. Tax credits for employers providing child care stipends, and reasonable accommodation for pregnant employees and break time and space for nursing mothers. That was sent to study committee. Again, you've already have the protections under the FLSA in that regard. Poll question 2. What proposed workplace bill concerns you the most in New Hampshire? Mandatory paid vacation leave that is paid out upon separation, right to work, limits on criminal background checks. I didn't mention that, but it would be limiting an employer's ability to search an applicant's criminal background check until after an offer of employment has been made. Further legalization of marijuana. We only have medical marijuana at this point. This would go to recreational marijuana, which I think is unlikely of passing right now, and potential increase in the state minimum wage. Which one concerns you the most? Survey says, wow. What's the old thing? I feel strongly both ways. Pretty much an even distribution throughout, with limits on criminal background checks being just slightly ahead of the others. Very interesting. So what it shows is that you're concerned and you're paying attention. Pay attention to the updates through your local HR association, through LaborNet, through the BIA, and so on. So news from the governor. Again, the May 7th mandate changed from a state mandate to best practices by employers. No vaccine passport for now, we know that. His focus is also on affordable housing, workforce housing. As we all saw in the last year, housing costs have gone up significantly. And if you're looking to fill positions, you need, in addition to a wage and benefits, you also have to have housing available that your employees can afford. Investing in apprenticeship programs and job training, money coming from the feds, in addition to what we're providing here in the state. And this recent development, New Hampshire joining a few other states, reinstituting the requirement that the unemployed actually look for work in order to get the unemployment benefit. Poll question 3, if you were in charge, what would you do? What would your #1 priority be in the workplace on a national, local, or just in your organization level be? So again, if you were in charge, if you were king or queen for the day, what would your #1 priority be? Mandating the vaccine and boosters for your employees, require uniform or consistent state and federal safety guidelines, direct regulators meaning state and federal regulators to give us all a break, at least for the time being. Revisit your recruitment, hiring, and retention policies given the new normal of remote workers and so on, or institute a rule every time there's a new law adopted, 2 others have to be eliminated. What do you think? Survey says, So the leading one seems to be looking back to revisiting your recruitment, hiring, retention policies. So whether you're in retention, you're looking at wages and bonuses, or other benefits that you might provide in hiring, whether it's going to be remote hiring and screening activities, and recruitment, how broad you cast your net. Otherwise, again, pretty decent distribution of the responses to the other questions. So where do we go from here? I think what we do is we take a deep breath, and it is going to be okay. I think obviously HR has had to deal with a lot. The governor mentioned in his remarks that HR professionals were truly on the front lines. They were the essential workers along with others. But you need to prioritize because there's a lot going on, and it could still be a bumpy ride remaining 2021 and beyond. Join LaborNet. There are 3,000 HR people out there, and lots going on, lots of activity and lots of information sharing. Stay tuned to Sheehan Phinney for our updates, both webinars, articles, client alerts, and so on. And yes, unplug this long weekend if you can. I'm going to, because we're running up against time, I could respond to the questions offline, but I want to go to our final poll question here. And that is, what have you found to be the most useful in this two-day program? The presentations were all timely, relevant, and useful. I like the poll questions and the feedback options. I like the two-day virtual half-day sessions as an option. Unlike our in-person, there are no lines at the buffet with this virtual seminar, or all of the above. Survey says all of the above. Well done. Well, thanks to Karen, Liz, and Brian today. Thank you all for participating. It's been a lot of information. As you'll see here, we've got credits available for attendance. The codes are here. Also, for those that would like to watch this again, you've got the materials available. You also have the recording that you can watch as well. But thank you all for attending. We really appreciate it and wish you all the best. Have a great long weekend. Thank you.